on you, but yeah. Are you naming that? Yeah. Okay. All right. We have a question here, there, and Anant. We'll just take these. Yeah, don't worry. We'll get everyone in before we break for lunch. Yes. Ananda, can you have the mic here? Adija? Yeah.
Thank you, Professor Surendranath. Good afternoon, everyone. My name is Vineet. I am a journalist with Scroll. My question for the panelists and for everyone here is, I was wondering what are the reasons behind the limitations we face when it comes to like the collection of criminal justice data. So as we've discussed since yesterday and today also, that there are it seems that we don't have systems in place for the proper collection of data. So are the reasons perhaps cultural, and in which case I'm interested in knowing whether these limitations are also there in other countries in South Asia. Why is it that our lawmakers and lawyers are not that engaged with data? And Professor Karthik mentioned that perhaps the fact that we don't have data and anything to do with data or policy analysis in our law courses could be one of the reasons. And the second part of this question is, which are the countries that have best practices for robust criminal justice data collection?
Okay.
And why is it, like, did they develop these systems fairly recently, or like were they always in place for whatever reason?
Got it. Yes. Yes, please.
Yeah, thank you. My name is Devyani Srivastav. I'm with the National Law School, Bangalore, and also associated with the policing section of IJR. So I have three inputs, comments, questions, all related to IJR, and all related to both the method but also the purpose of IJR. So one thing is on the issue of trusting the data that Valay mentioned. So I want to add a caveat to that, which is that yes, we go by data that is publicly available, that is officially published. But wherever there is a glaring discrepancy or a gap that stands out, we do probe. So for example, in the last edition of IJR, when we were looking at the data on diversity in police organizations, what stood out is that the state of Andhra Pradesh, after being divided from Telangana or after the creation of Telangana, the ratio of women in police has shot up significantly and it has crossed 20%. But when we probed that data, what stood out is that they have added 15,000 personnel under the category of Mahila Thana, and it's a new category that has been created, which is sort of village defense function. So not officially police personnel, but assisting the police, and they are counting that number as women police personnel. So while it was published as that, we retained the reporting as women police personnel, but we've added an explanation that points out that this is first of all challenged in court and it is unconstitutional. And secondly, the effort is to engage with the police department on such policy measures thereafter. That links me to my second point, which is how data, a lot of the point is made about how this data is already available, and so what is the value addition? I think the value addition also in terms of identifying patterns is to link not just with data patterns, but therefore the gaps in policies and standards and benchmark. Because this is a ranking exercise, obviously we take data only where there is a benchmark that exists or a standard that has to be complied with and against which states reporting can be measured. But how are those standards set in the first place? What is the process for reviewing it, strengthening it? Those are the conversations that therefore we are able to have because we are now collecting year on year, or we are reviewing year on year data. And there, I think, things like how is the sanction strength in the police department even determined? And I know that it's an exercise that is reviewed every 5 years, but does it actually happen? how robust is that exercise? Standards like what is the area that a police station should service. Something has been laid down by the National Police Commission decades ago, but there isn't any relevant, recent, up-to-date standard. So those are the conversations that we are able to have on policy matters through the data exercise. That's the second part. The third is actually a dilemma or a challenge that I wanted to share and invite any suggestions and comments. Because IGR is a ranking exercise where there'll be a number 1, number 2, the difficulty is that actually what we're realizing is that there isn't a linear trajectory. A state that is number 1 this year will fall drastically next year, and vice versa. A state that is actually low in the ranking will rise. And that's partly because of the precariousness of the parameters that itself are being used. So one thing, again, that determines ranking is the amount of vacancy in departments in all the institutions. Vacancies is linked with recruitment cycles. Recruitment cycles take about 1.5 to 2 years to actually complete. And so therefore, a state that has done recruitment in 1 year will rise up automatically in the ranking. So yes, there's a pattern that we are able to identify, but what is the meaning of that pattern when it's not consistent? And so therefore, that's the challenge where we have when ranking is concerned, and I don't know if there's an answer to that, whether, does that mean that the exercise is therefore not as effective as it would be where there's a linear trajectory, or not, that there are still insights to be gained from this exercise. And finally, just on a non-IGR point, the issue that Valay pointed out is that there's even there's gaps in the way in which official data of these institutions is being seen within the institution. And that, I think, bears out more and more when you do qualitative research. And this is an exercise that we're just completing in Karnataka with the Karnataka State Police, where we've again done a study on women in police. When we asked the women in the Thana level, what do you think is the representation of women in your state? Everybody said 25-30%. It was way off the mark. What do you think is the target that the government has set for representation of women? Again, both women personnel and male personnel had, their knowledge of that was way off the mark. So what stood out is that the communication within institutions about policy issues, about data that exists, is not happening effectively. And so that's the gap that, again, research could potentially fill.
Thanks. Yes.
Thank you. My name is Anant Kumar Asthana. I'm a child rights lawyer based in Delhi. Three things which I wanted to place for consideration for the entire house is that all of us use quite a lot of data in our work, right? And there is a substantial body of work on data justice. And this 2-day conference brings lots of us together, a lot of us from children's rights, a lot of us from prison work, and this is something which is a very unique opportunity we all have been dreaming about. So thank you, Anup, and thank you, India Justice Report, Maya, for bringing all of us together. Several years ago, when Nirbhaya case had happened, right? There was a data put up on NCRB that 30,000 figure is the number of children, right? At that time, some engagement happened with the NCRB, and we said your data collection is not aligned with JJ, because in JJ we don't have an FIR for offenses below 7. So you also have to include DD entry if you want to have an actual number. Now 10 years have gone, there is no progress on that, right? That's one example. Second, there is a number of children in conflict with law quoted quite an often, right? It's again 30,000, 34,000. But that is quite misleading number, because a large number of children are actually pushed into prisons. Thousands of them. I Pro Bono had just come out with a report, 11,000 children in, I don't know how many years? 5 years, right? Those children are not included in the JJ data, right? And they just go disappear. They are neither in the criminal justice system nor in the juvenile justice system. The invisible children shielding a completely illegal, corrupt practice by police institutions. Then the way the JJ system has evolved, the juvenile justice system has evolved, the whole performance appraisal, Supreme Court and the High Court judges somehow have got fixated with calculating pendency, and how many cases you dispose of becomes a performance indicator for all the judges. I recently came across an example where some magistrates were being rewarded for disposing of 3,000 cases, 4,000 cases. The whole point is missed because JJ is not about numbers, juvenile justice is about rehabilitation. These three examples I have given just to bring on board the crisis we are facing. We are not moving forward. So my ask is, how do we enhance as a collective our negotiation capacities with the state institutions and policy makers from here, moving from here? That's one, on and around data justice across sectors. Second, which I hope will emerge, this whole 2-day consultation, many of us have been trying to make sense. Some of us could not understand at all what the speaker spoke about, and that's the situation that so little we know about it. So thank you again for that. But then, can we move towards identifying 3-4 priority areas which represent these cross-sectoral aspirations? That's second. And third is, how do we move forward from here, and in what direction? I'm not expecting an answer from anybody, but these are three hope I have will emerge from this. Children's rights groups have met, and we are going to again meet at some point of time. So that's a little progress which is going to happen definitely in children's rights groups, but collectively there must be some way forward from this, right, which I hope will emerge. Thank you.
So, Pooja, if I may ask, how do we understand, I mean, just taking off from Vineet's question and before we get to Anand, how do we understand why this is the state of affairs, right? That data is, the state data is in the manner that it is or is not. Is it just a capacity question in that sense? The state does not have the capacity to generate this data, and therefore it is not accurate, it is not sufficient, it is not collecting data in certain areas. How do we understand this state of affairs?
I think there can be a straightforward answer, in the sense that I would be that person who would want to even disaggregate this, this question and try to sort of locate it in particular spaces. So let's say for instance, in the RTIs that I filed specifically for the special unit gave really great data, and that great data included them saying, even as they are mandated to keep accounts of data, at least since 2002, I know the special. At least since 2002, I know the special police unit has been digitizing it, and definitely after 2008 when they were restructured. Yet there were at least 3 or 4 districts that have given me official orders to say we can give you data for about 5 years, and they've attached that office order that says Roznamcha guard files, complaint files, case files, etc., given to Khadi Gram Udyog for pulping and making handmade paper. I want to figure out a way of even dealing with, let's say, excessive information. I don't need this information. It would have been just enough if they had just said, nahi hai hamare paas, or we cannot provide it, go appellate, go to CIC. I might have done it, might not have done it. I'm just saying that I wish there was such a broad brush, right, answer where we could impute pathology. Yeah. Yeah. Where we could impute, where we could just say, look, there is your interiority is so corrupt. कि तुम्हारी intention ही नहीं है देने की तो तुम दोगे ही नहीं. I'm saying let's take it. So I think like a little nuance in, being cautious about numbers not being data, and this kind of answer also being, how do we think this? How do I bring pulping of data into now conversation, for instance. I'll give you one other example. Data sometimes comes in the form of, let's say one of the things, there is a way in which some police practices get absorbed by courts. One such practice in police units used to be that they will not show the copy of the complaint to the respondent till the filing of FIR. And of course, that used to lead to networks of bribe and so on and so forth. Come RTI, and we have respondents basically taking this, asking for complaint copies and so on and so forth. And police officials still today have been saying we will not provide until an FIR has been passed and so on and so forth. This police practice gets absorbed by the courts under mediation rules now, which is inclusive of pre-litigation work that the police does, mediation works that the mediators do, counseling work that the counselors do. I'm just saying this is also great data because it helps us think, let's say the question of RTI, as in it allows us to pose the question of RTI not just as being tied to accuracy, inaccuracy, but to, okay, how might we think that there's a very different kind of biography of an institution that becomes available precisely through RTI.
Right.
So I think that would be my broad answer.
Yeah. Yes, Vijay.
The way I see it, I don't think there is a problem of capability. Just responding to your question, I think it's a matter of capacity. And there's one issue that Karthik had talked about yesterday about the difference between paperwork and data. So the government generates enormous amount of paperwork, but to convert it into data requires a separate department which will do it. Now, if you look at the general state of criminal justice, there are across the board 30% vacancies. So they don't even have enough staff to do their regular work. And on top of that, if these kind of layers are being added, there's a lot of pressure now from government as well as from civil society, give us this data, produce this data. But they are not giving them the people to record and maintain that data. So e-prison software, for example, has been created. But who's going to do that data entry work? Have they created posts of data entry operators in all the prisons who will do this work? No. Some constable is being asked to do it, who is a little more educated and computer savvy, along with his other work that he has to do. So I think that's where the problem lies.
Feel free to respond to any of the questions. Yeah. No, just a second. No, we'll just take a... Yes. Pavitra, Rukmini, and yeah. I'm trying to identify people who've not spoken. Yeah, and sir. Yeah, Ajay, I'll come back to you. Yes, go ahead.
Yeah. Hi, everyone. I'm Pavitra. I work for a research organization called XKDR Forum, and we are based out of Bombay. So I don't really have much thoughts on the limitation of the existing data itself, but I wanted to just think about using the data for measurement and reforms. So just a bit of a background and caveat, I've been using courts data for about 4 years for measurement and a couple of years for reforms. But the caveat is that it's mostly been for civil and commercial suits, and the most I've gone to criminal is 138 cases, so just putting it out there. So as far as the India Justice Report is concerned, I think that was a lot of information, and I don't know how you have been able to carry this out forward for so many years. But I did think that we could probably go a little bit one step further for the analysis in terms of you have this great way of putting these states into bands, like, okay, judge to population ratio or the human resource or the budget, band 1 states, band 2 states, band 3 states. How do we link it, right? For instance, if you can calculate the time to first hearing in different courts, okay? Now, just thinking from a framework of input and output, if you see that there are states in the top band that's able to give time to first hearing at a slower rate than the states in the lower band of judge to population ratio, which is able to give time to hearing much faster, then you can sort of cancel out the factor that, okay, maybe judge to population ratio is not what matters in this aspect, right? Then similarly, you can look at HR that way. Similarly, you can look at infrastructure that way. So we have always sort of tried to stay away from drawing causalities because we don't have that data. we don't have the human resource data, we don't have the budget data, but you guys seem to be collecting that data. So how can we link it to the working of the judiciary and the inputs into the judiciary, right? So that is kind of one of the thoughts that I had. And the second thing is, I don't know how the people working in the space are going about it, but what are we seeing as the unit of change or measurement? To Valay's point on zooming in, right? So justice, especially in the criminal space, is extremely a state subject. And to a great extent, states have the authority and the ability to make change whether or not they get a central government approval. The consortium that Karthik mentioned went about doing it at a state level as well, because you can get the Chief Justice of a particular state high court to approve it. So instead of, trying for a top-down approach that a law has to be passed or a central change in e-courts or e-police that needs to happen, can we start looking at states that there are a lot of justices, joint secretaries who are actually open to sort of, hearing other people's civil societies. So can we maybe, then it becomes a good learning for other states. Then they get competitive, even we want to be able to make this change and so on and so forth. So in terms of measurement or reforms, can we start looking at in a much more bottom-up approach instead of trying to cover it all?
Right.
Yeah, that's...
Just pass the mic behind you.
Thank you. My name is Rukmini. I used to be a data journalist and I now run a public platform that builds socio-economic understanding about India through the data. I apologize if some of this has been discussed yesterday because I only came in from Chennai today, so some of this may have been taken on, and I have some, I think I share Pavitra's sort of pragmatism about what can be done with the data that we have, and so my questions are similarly pragmatic. Valay, I was quite curious about this slightly Niti Ayogish strategy of ranking states that the IJR follows, because I believe our, your work, our work, the aims are similar, building broad public understanding, accountability. I was curious about whether this ranking system does seem to be building the maybe the positive competition that one expects, only because the ranking is fairly complex. So it's not one of those, hit 100% electrification and you come to the top of the ranking sort of thing. So I was very interested in understanding, the motivations for this ranking, because this doesn't really happen in this sector as such, as well as whether the sense is that it's being, these motivations are being borne out. The second was for this broad group, because since again I share the other speakers' feeling that it's great to have everyone here under one roof. One sort of constant frustration I have had is that, and an earlier speaker spoke about how the CI, the Crime in India report, does have every FIR from every police station with a big asterisk against it. The annual frustration that we have about getting only the report and not the CSVs of the data that has gone behind it. Now we know that this means that we are missing the actual number on every IPC section that's there. This seems like such a simple ask, and again, building on the enthusiasm that various speakers have about individuals in the system, has anyone had any headway towards trying to ask for that CSV of what the actual number is? It really, I understand not wanting to put out because of the issue of double counting, but why can it not be provided to any, or has anyone had access to that, that sort of pot of gold? And my last question was actually to Anup, when you mentioned the under trial thing, and you sort of ended it with this point that it shouldn't be hard to do, nobody's really opposed to it. Similar to the earlier point, your point about the prisons data and are there ways, RFID tracking, are there ways to sort of bring, without being that boring technocratic person who tries to bring tech solutions to everything. If it seems that there isn't opposition within the system, that it is relatively easy to do, then what is it? Why? What is the actual? I mean, I didn't understand the end
Oh,
of that.
why?
thought.
Okay.
Why hasn't it happened? I didn't get it. Or where do we need to put our energies to make it happen? Because, and I'll talk about this in the afternoon, but my sense is that the injustice of the under trial issue is one that travels quite far. So if there are, if there are collective shoulders to put somewhere, where should we be putting it, considering everything else seems to be aligned over here?
Got it. Yes, please.
Hi, my name is Nikita. I wanted to understand when Ms. Pooja spoke of how
Sorry,
when
could you also
look
just
at,
tell us your affiliation and what you do?
I'm a researcher, I
That's
would
fine.
say. Yeah,
Yeah.
okay. I wanted to understand that, Ms. Pooja, when you spoke of how when we look at bureaucracy through police, it tells us of heightened individuality because it gives us a name and a name is attached to it and it leads to accountability. And what I wanted to understand is that a system which is most of the times unnameable, unseeable, and for say a person who has been incarcerated, the person would be like, "Acha, ye mera judge hai," and the person would be like, "Mera SHO ke paas mein case hai." The person wouldn't even know the name of the SHO or the judge, and the judge keeps transferring as well. A lot of times when we are filing RTIs, we don't even know who the PIO, the name of the PIO is. So what I'm just trying to understand that in effect, when a system is unnameable, unseeable, how do we then see it through the individuality that you were speaking of? And how can it help us cultivate transparency in data? And especially if we are speaking from what Professor Raghavan spoke of, that, broadly, that data not just for public dissemination, but also for prisoners. A prisoner should be able to know that, this SHO is not just a post or a system, but a name attached to it. So broadly just trying to understand that how can we see an unseeable system?
This Nikita, right? Yes. Sir.
Thank you. I am Dr. Amandeep Singh Kapoor. I am from BPRND. So I am taking a stand on behalf of police, so allow me to stand and talk. So there are two disclaimers. When we say criminal data, so that data is being generated either in digital form or in paper form across all the pillars of criminal justice system. And I represent only the police. Other one being the prison, the e-courts are there, the prosecution is there, the forensic is there. Their all data is either digitally there in ICJS or with their own department is there at the respective places. Second disclaimer is I am representing BPRND, and the police data, the data crunching organizations of police are, one is BPRND, one is NCRB. Now, the first question you will ask is why two organizations? Because we deal with non-criminal data majorly. We deal with the logistics, the assets, the manpower, all other things that many of you were generally talking. For criminal data, there's NCRB. So I represent the BPRND, but I know the data ecosystem, so I'll like to then come about the things, how the ecosystem is operating. So even if the criminal data, there are two, and non-criminal data, they are now, after the Data Protection Act is there are two issues. One is personal data and one is non-personal data. So question is compounded further by whether we are able to give the data as the CSV files you were talking about. There's a lot of confusion there. Should we give it? Should we not give it? But I'll come with the last. There's a silver lining. You will soon get it, I'm sure. So now thing is, first we'll like to see the ecosystem before we call it pathological or all of us police officers as conspirators. So I'll give you an analogy. You sit in a dhaba and you call a Michelin star menu. And you ask the dhaba owner, why are you not keeping a Michelin star menu? And then start rebuking him, and you are not having a culinary taste and all that, and you are promoting a dhaba culture, and you are so and so. The problem is, policing is a state subject. So data has to emanate from states. States are as good or bad as they are in terms of data crunching, data collating, and data disseminating. The dhaba owner is maybe not having the capacity. He's insular. He doesn't know what I'll do with a Michelin star menu. And that may also be not his priority. And when I say insular, recently when CCTNS was in place and we started sharing FIRs, you know who the first consumer of those FIRs were? The cyber criminals sitting in Mewat. They started taking those FIRs from downloading from the CCTNS and then using it as for their own hanky-pankies. So that insularity also has a method behind that madness. So these are the issues that we have to realize. Data will only come from center, from state. Just go to a police station and see how the so-called, the only data entry operator we have is our poor constable. He takes 2 hours to chalk a FIR on a CCTNS portal. And not to talk about the case diaries of all FIRs now that mandatorily has to go into the CCTNS portal. So that's a difficult job for one single constable, or at the most 2, at each police station. And then we are asking him to also generate other data, not knowing how it is going to be used, whether it is going to be used, and he's not prepared for that. So I agree with Professor Raghavan that we need a separate sort of a mechanism where data should be made understood to the lowest machinery. So this gives us they'll just make understand how to generate data and then take calls with the reliability, the accuracy, the legitimacy, the granularity, and the usability. Now coming the thing that you were saying, that what are the priority areas and how to look as a way forwards. So now the good thing is the Government of India is coming with a national data governance policy. I think many of you must be knowing that. And they have also spread the word out to ministries. Every ministry will going to have a data management unit. So one way forward is that then we will decide what data sets are to be given to the public. And that will be a very granular exercise. And we are already into that. I'm the member secretary of the committee of MHA who is looking into the data governance. Second part is the AI mission. And AI mission is all about data sets. Whatever you want will be available as data sets in future, maybe 5 years down the line, when the AI mission has a timeline and it gets rolled up. And then the last 3 is technology templates and how to make it better. If any of you want to do a research project, just, I'll chip in if you want, just go to NIC and ask how the CCTNS was rolled and how now the e-Sakshya, how many of you, I don't know, heard about e-Sakshya? The new criminal laws now say that every search, seizure, and investigation has to be audio-videographed. So for that, NIC rolled a application that was e-Sakshya. If CCTNS is bag of goofiness, blunders, everything gone bad, technology gone bad for criminal justice system, e-Sakshya is exactly opposite. And if you want answers how data should be read, seen in the ecosystem, just do some research on how NIC rolled CCTNS and how it rolled e-Sakshya. Thank you.
Thank you. Yeah, so I will come to you. I will come to you, ma'am. There are 2 people there in the middle. Next, third. It won't. I assure you, it will come to you. Yeah. Sir, no. Are the 2 of them there and then you, ma'am? Absolutely, yes.
Hi, my name is Shruti. I work with Vijay Center for Legal Policy. A reflection on the discussions from yesterday and today. We've spoken a lot about capacity problems in having proper data for the justice system. And I just want everyone to reflect also on the fact of if we do have data on whatever we want, can we also think about how we can empower institutions to actually use that data for betterment? Because right now, otherwise we end up collecting a lot of data, and data cannot remain just for the purpose of research. At the end of the day, it has to be for improvement of systems, and I think that that's something important that we should really look about when we talk about state capacity. So yeah, just a food for thought.
Yeah.
Hi, I'm Ankita. I work with the Migration and Asylum Project. I've worked for a while with the Fair Trial program, and I just wanted to quickly outline recent data trends and like what has been the communication with different courts, especially to Karthik's point about whether or not there has been any initiative taken by in terms of best practices with prison data that Professor Raghavan presented. So one of the first few things is that there is a UTRC Under Trial Review Committee that now looks at like 14 different sections of people who should be eligible for release and who have been overlooked by the system, which was in inhuman conditions in prison case, in which NALSA had proposed it. However, I think the experience with most prisons has been that this UTRC meetings, one, do not happen. Two, if they do happen, the data is hardly complete, and there is it is absolutely not a reflection of all the people who are entitled under these 14 categories being represented and put before the UTRC. Then it was, I think, a trajectory between 2017 to 2023, which was, there was a question of how are under trial prisoners going to be released on bail if the prison itself does not know that bail has been granted, because there is no communication between these two in the first place. And then there was a judgment in deficiencies in criminal trial saying that this order has to be communicated. But again, the thing about pillars not speaking to each other is that the Supreme Court passed that order, but I mean, experientially, I've never seen magistrate courts or sessions court in their order adding that this has to now be sent to the prison, and it is only release orders that are still communicated to prisons, which means that there is no way for prisons to know how many people are waiting for just compliance of their bail conditions, not grant of bail. The other issue is that even if you consider that these orders start getting communicated, does the e-prison module even have a tab for registering that bail has been granted to an under trial prisoner? And no, it doesn't. The NIC in 2023, I think, made a commitment in policy strategy for grant of bail, saying that yes, we will include all of this information, we'll create different access levels for DLSA secretaries and for prisons and all of those things. But practically, again, like Anup said, it's a huge data dump that you still get, and there is no segregation of this data. There is no way to look into these different facets of the data. And to this date, for reasons best known, e-prisons does not speak to e-courts, which would honestly fix so much, because e-courts is a much more reliable system, and we could go over a lot of the issues of like don't know the police station, don't know the FIR number, which was spoken about in the presentation. And if these two just start speaking to each other, that could be resolved. There is ICJS that has been spoken about, the interoperable criminal justice system, which is going to be all the pillars of the CJ speaking to each other. So there are so many facets and so much communication and so many decisions in the last 5 years that have focused on the importance of data and how these data systems need to speak to each other, but there has been a huge lack in percolation of that data and actual implementation of these practices, which means that none of the benefits that need to go, especially at least with respect to the under trial prisoner, has actually materialized. Thanks.
Ma'am?
Thank you. So I think Vijay Raghavan, Professor, he explained the position very well, and so did Dr. Amandeep. I had specific response to your questions. Issues. One was that suppose a police station keeps a person in the police station for 7 days. Why is he not or she not being shown as in custody, which we just cannot. It is a sad fact that sometimes citizens are kept in police station, but it's not recorded, so that will never come in custody. And it's a fact that they are brought, no record is kept, but when the IO who is overworked, who has, by the way, cyber officers in Mumbai are having 80 cases for investigation per IO, and Amandeep was saying that it's much worse. So IO asks his assistant to get X. X is brought, he's sitting there in the police station, but the IO investigating officer, when he gets time, he will talk to him. He may even keep him for a day or two, but this will not emerge in our data, that I accept. Preventive detention, the contradiction between number shown in prison and in the Crime in India report. Here is where I want to flag, not only do we have data gap, communication gap. So there is data gap, there is communication gap, but there is also understanding gap. Maximum preventive detentions which will be seen in crime in India are under 151 earlier CRPC, and that detention will be only for less than 24 hours. So the figures in CII will be much higher any day. I can keep them in my police lockup for 14 days. I need not send them for the judicial custody. All these people less than 14 days detention would emerge as data in CIA but not in prison. Therefore, preventive detention figures in prison in India would always be much lesser than in CIA. This is what I am saying, understanding gap. And therefore, we should have invited more state representatives.
We did. We did actually.
Third, natural death. When you are showing finger at the prison department, and I am again saying, yesterday also I said, let's not get into too much of state bashing, and as Professor Muralidhar, totally independent academician, said that besides being critical, we have to be supportive. Now, most prisons don't have doctors. If an inmate dies, the prisons which have medical officer, he will certify the cause of death. If I don't have a doctor, the local municipal hospital or the district hospital will certify the cause of death. Prison officers have no say in what is being written as put up in the post-mortem report as cause of death. So, for heaven's sake, don't think that prison officers are into certifying natural death when you have a suspect. So these are the 3 points. The people in the police station not in proper custody will never be on our record. Preventive detention would always be more in CIA than in prison in India. And then cause of death in the prisons is certified by the doctors. Prison officers have nothing to do with it. Yeah. And be supportive and not be critical all the time.
Thank you. Thank you. Yes. Sorry, Ajay has had his hand up for a while. Ajay, Swagata, and Sana. Yeah.
Well, as ma'am has just spoken, and I think that I endorse the
introduction.
I am Ajay Verma, advocate and also currently heading International Bridges to Justice India. We are working on prison reforms for a long time, and collectively with the Professor Raghavan, CHRI and all, collectively we are doing litigation, Supreme Court also. So ma'am, I wanted to inform, perhaps this has not come to anyone's notice. Professor Mr. Murali has spoken. The data given by the NCRB was questioned by the Honorable Supreme Court, in which they said what is meant with the natural and unnatural deaths. So that questions was asked by them, and that please clarify the deaths in the prisons. So that data aspect, and thereafter the Honorable Apex Court has directed the compensation of certain deaths happened in this, and suo motu directed all the high courts to register PIL in their respective courts. And these petitions are still pending, waiting for the compensation to be disbursed to the next kin of the person who's died. The second is Professor Vijay Raghavan has shared a presentation and certain issues. Perhaps Professor Raghavan, this is an issue which is going on in Maharashtra, but I think considering Delhi or some other places, and one time we filed an application, best practices of particular state be adopted in other places. Let's say that the status is not known to the prisoner. Who is my lawyer? What is the next date? Especially the e-kiosk system, the data, even in Tihar, the kiosk is there available, but the data is not updated. I could see the portal of e-prisons today. There is a tab of e-kiosk for prison. But then it is not being updated in the respective jails. So that is necessarily in all the jails, so that the prisoners should be aware about it. Then linking of pan-India data. Perhaps as you have clarified, I just about the bail compliances, which is actually in the Supreme Court that the strategy matters. So in Delhi High Court, while 230 prisoners I found in Tihar was already got bail and could not be released, I filed a PIL, and there is a directions given by Honorable Justice Geeta Mittal. Perhaps in that they made it like Arnesh Kumar, the judge responsible, that after the bail order is passed by the judge will track the matter whether this person is released or not, and then involved a process of called risk assessment and can release on personal bond. In the Supreme Court is now that exercise is going on. Perhaps that we can intervene in that matter on a national front and then see to it.
Ajay,
I'm sorry.
have to.
Sorry.
Yeah,
The
so
last is there is how the Legal Service Committee of Delhi is following the protocol. Perhaps I can share with everybody. The communication of appointment lawyer is not only shared by the State Council but also to the prisoners as well as the police stations and the respective lawyers. So that perhaps the protocol, if that is followed, then they will have details. The last comment is about the details on e-prisons. Professor Raghavan, in the e-court services, we need to somehow pitch at some strategy level. There is a lawyer's name is always mentioned, but there is no contact details. So when we have a specific case detail, CNR number, then we can have that tracked out and lawyer's details will be available. So that can be shared with everybody. Thank you so much.
Thank you, Ajay. Swagata. Unfortunately, we're going to have Swagata and then Sana, and then there are responses that are required. So we'll wrap up with that.
As researchers, how are we strategic about data collection? We understand capacity. Many of us working in specific sectors, we are fairly familiar. Mine is not working. Yeah, can you hear me?
No.
Yeah. Okay. The point that I was trying to make is how can we be strategic as researchers, especially when many of us here are working in sectors where we fully understand capacity, we fully sometimes even empathize with that police officer or the prison staff or the childcare institution. So what responsibility do we exercise when we are asking for certain forms of data which we know are not even collected at the very inception? And then you know that you're going to get data you cannot use. So somewhere I think we also have to reflect on what are we asking from them when you know from the get-go this is data that's not being captured in the system at all. Just to substantiate what I'm saying, the Supreme Court Committee on Juvenile Justice has undertaken this exercise of collecting data from states on children in conflict with the law. The questions they're being asked, and they're being asked data over a period of 5 years. And mind you, these are questions that are being asked for the first time. So you don't have this data that has been ever collected and is now being asked of staff that please tell me from 5 years, like give me annual data on this. We all know, and those of us working in JJ, we know it's all fudge data. And now that the data has come, the conclusion is that we can't rely on it. We know that this is not trustworthy. So we knew this from the beginning, but you've subjected the entire system to collecting this data. So what do you learn from this exercise? Maybe one takeaway is that, okay, now you need an integrated MIS to actually capture that data. So has it served that purpose? We will only know if states actually take on that exercise. Second, I want to point to the invisibility of certain populations in data. We've been focused a lot on criminal justice, and we recognize that criminal justice is not just about adults, it's also about children. Although I did talk about this, even if you look at police station data, there are child victims also who are kept in a police station, and there's no record of it. There's also Juvenile Justice Board orders. You have access to e-courts, which gives you orders of all trial courts, High Court, Supreme Court, you have access. You have no access to the orders of the JJB and the CWC. So you're looking at a data, absence of data completely. So the starting point, I think, depending on the sector we work in, is very different. The kind of advocacy that we have to undertake is also very different. You may be dealing with the same department. You may be dealing with the Home Department, the judiciary, but the starting points are completely different. The third is, what is our expectation of data? We seem to be in a hurry to, get to change and see something that is measurable. Sometimes data can also be something that triggers a conversation on what is needed. And then that change can take different forms. So just, to be mindful of that. And finally, I want to talk about funding. I don't know how many funders you've invited, Anup, but some of the work that...
None came.
Huh? None came. Yes, so I hope this point does go across to them. Much of the work that I presented yesterday, I would say is underfunded. So, you get a project for 6 months, but you know that you worked on it for a year and a half and you didn't give up on it because you want to complete that research. So just to make that point that yes, we are cottage industry, we will be cottage industry for, I don't know, centuries to come, unless the funders also recognize the value of research. So research is not a priority. It's that data collection is not a priority for somebody in the system. It also doesn't seem to be a priority within the funding community to see what that, that result of that research can be. Thank you.
I'm Sana Das from Life and Liberty Foundation. We have a focus on safe societies and safe custody, and we're working on prison reforms. My questions and responses would be to Valay and to Professor Vijay Raghavan, and also some crisscross responses to the discussion that's been happening since yesterday and particular points today. So, we've been looking at the availability, starting from Professor Bajpai, the availability of data and what we really need to look at, the dynamic data, to the challenges that we have with official data. So my question to Valay would be, you said in relation to the dynamic data on the 500 RTIs that you filed on compliance to Juvenile Justice Act, that you received a lot of what you may call, unneeded or unrequired data. And I was just wondering why one would not, I think yesterday also we had someone saying that I don't need this data, I didn't ask for it, I don't need it. But just in relation to what Dr. Pooja just mentioned about, being able to track the biography of an institution by just looking at, the absurd data that one might get. People across are also engaging with what one may call nonsense data, because it really is not nonsense after you are able to sort of apply some kind of motivation to it. Is why is it that we have received this kind of response? So I would say, that either we are saying that we are not equipped to deal with it because maybe it will take us somewhere else, or we understand that it is to distract us, or to or whatever, or they're just fulfilling some compliance element by just giving you a reply. But having said that, I would still say that this nonsense data may have some sense and may not need to be ignored. We are probably ignoring something about the larger, institutional practice over there. We should still engage with it. That was a response. Also, regarding the disappearing data that you mentioned about the, the reserve, armed reserve police, I thought it was, coming from looking at court production not happening in many states regularly, the peshi not being a regular thing, and in jails like Bhopal Central Jail, what we've seen is that it is just paper production. And this is where we would like to look at that kind of data, because it is this police which is responsible for the police, the escorting to the courts, and we are seeing this, in a large number of cases. The custody ticket that Professor Raghavan talked about, that shows all the dates, but they've not been taken out. People have not been taken out for 3 years in a row. You have that kind of gap. So this data is meaningful if one were to analyze it. Not only from the point of view of gender representation, which we are studying, but also from other aspects.
Sana, just to rush you, sorry.
I would like to then go to Anup, what you mentioned, the questions that you left us with about where, the dichotomy between what the state is tracking and what needs to be tracked, and with regard to under trial problem, where the problem is. One is, with regard to bail, I would say it is that last mile where we just don't have any data whether bail is being granted, but the conditions are such that they're not allowing, the orders are not allowing people to step out. Yeah. And that is where the area of sureties, the kind of sureties, who's tracking, what kind of surety conditions, every magistrate would now know about Satyendra Kumar Antil versus CBI, but why? They're not reforming the conditions that they're applying. 50,000 to 50,000 sureties, local sureties, I mean, completely in violation of Satyendra Kumar Antil. They know it, but there is simply no tracking of that kind of data, that extra mile. And who's performing that role? Is it lawyers who are performing that role in terms of fulfilling the conditions? Who's bringing in the sureties finally? Who are these sureties? And is the release happening in terms of, let's say, personal bond release? Where is anybody tracking the number of releases on personal bond? Yeah. That data is missing, and so in response to you in terms of where we should put shoulders together, this I would say is definitely an area to look at, study the conditions that are being applied by magistrates, and really to pose a question there. Yeah. Yes. Sorry, just 1 second, because I have to respond to Professor Raghavan, because I just wondered, because all the 3 cases that you talked about, they were all about women prisoners with a mental health condition, and therefore my question was, what is your hypothesis? Is it about data, or it is about bias? Because the problem of paper book not being available cuts across. But we have cases like this where, it really is very, very visible in the case of women with a mental health condition. There is, I mean, we've come across cases where the woman suffered from postpartum depression, and it was a case of
so now we'll have to move on.
Yeah, sorry. Just to put
got it.
So
I think there are questions for all 4 of us to answer. Pooja, if we can start with you, Nikita's question on how do we see something that is invisible, right? And if you could.
I think Nikita's question got answered. Dr. Amandeep picked it up, and I think she picked it up. I think hers was really sort of in terms of how do you identify the PIOs, for instance, every PIO's address and phone number, rank is on the reply that is given. But the other point that she raised about integrating, I think my sense is that your question has been answered with the kinds of efforts it would take to specifically sort of name, SHO and IO and so on and so forth.
Essentially trying to understand if even if there's a name and address, or say, like, for instance, we know that advocate lawyer's number is not there. But even if there is a name and if there is an identity, essentially at the end of the day, essentially what ends up happening is that it becomes a system. We end up criticizing not just the individual, because you have talked about individuality and accountability. It doesn't become about saying that this individual did this to me, but this particular system did this to me. The police came to my house, and the police came to my house, so what I'm just trying to say is that it doesn't become about the individual but the system in of itself. So how do we bring that accountability and transparency with the individual?
I'm saying that I don't quite know how in each case you're going to do this, but in some ways, let's say you would have Vigilance and Prevention of Corruption Act, of one kind or another. Corruption, as it were, most expansively as it was thought of, would be some of the mechanisms. But would you be able to, as it were, like, for instance, every police station today, at least in Delhi, has a little signboard that says, if you are not satisfied with the working of an official, please contact XYZ, XYZ. So I think those are internal ways, but a slightly more specific question would probably help. I can speak at the police station level, but for others, I did think that the answers that came from, Dr. Amandeep and her were helpful. I just wanted to take half a second more to just respond to Dr. Amandeep. Because pathology was my question. My word. I didn't mean it. I meant it the other way around. That we end up pathologizing the police is the easiest thing to do. I wondered whether there was some communication gap. I meant the opposite. Okay, then we're good.
Yeah. Valay, the question from Rukmini about the ranking and the motivation for getting into a ranking system. Yeah.
Yeah. No, lots of great thoughts here, and I think 66% the purpose of this colloquium has been served already. 66.5. Do we
trust that statistic?
Yeah. No, we don't. We shouldn't. But I'll start with something completely different. So in several of our myths, we know that Lord X left town Y 9,76,000 years ago. That's 9.76 million years ago. So data and the specificity of it works. Numbers do help a lot in making your arguments. In the later, actually historical period, we have Turkish accounts, Persian accounts, and in most of them you'll see 50,000 people were massacred. 500 camels worth of loot was taken from town X to wherever, some other continent. So let's just agree that as a country, we have had a history of using data to serve our own ends, and we continue to do that. And it will never be uniform, it will never be perfect. On Rukmini's point, and then I have many other points actually.
But only Rukmini's
But on Rukmini's point, I would say that this is the third edition. COVID was also a factor. It is a Niti Ayogish or Planning Commission-ish report. Yes, it is. It has made accessible this very complex set of information sets to many people. And our assessment was that the data was very siloed. Even the sector was doing research. So judiciary was just judiciary, child rights. That's my first exposure to the space. Child rights is just child rights, and so on. So what this report has managed to do is just bring it together in one place. So that's stage one. Fostering competition between states, no hard evidence to prove that, but anecdotally, in one-on-one conversation with serving officers, yes, it has made some impact. I'll give you a funny example. In Bihar, this report was put behind autos as banners, and actually some billboard in Patna, that their share of women was 25%, and it was the first. The Law Minister of Tamil Nadu cited the report in their assembly. So when it serves them, they cite it. When it doesn't, they ignore it. We have to live with it. That's a fact of life. But I think on the other points, and especially to Dr. Amandeep, we are publishing crimes against women data. It is something that cannot not be published. It's a political hot potato. What about helplines? Can we encourage governments to put out data regarding helplines, the number of calls that are coming, what is happening to them, how many of them are actually converting into FIRs? Similarly, cyber crimes, which is an area we should talk about. A lot of financial fraud is happening. We are particularly gullible in this country, and that data is also, I think there are officers in UP, etc., who are trying to push for that data to be made available much more. So, but what is not available? For example, Directorate of Prosecution data. What is the funding for prosecution directorates? We are also, IJR has started doing an assessment of budget documents of 26 states. And what are we finding is that the Advocate General's office, for just an example, is funded much, much more than the Directorate of Prosecution. Now, if we were to enumerate the prosecutors in every state, the infrastructure available to them, and correlate it with their funding, correlate it with dependency, and so on. And then similarly, the last point, Anup, is on training. Why is it that on training, no department, no subsystem is willing to put out more data, even if it is qualitative? So isn't that a reflection of the state, the quality of training, or the priority that is accorded to it? Therefore, we end up with some crude metrics like personnel workload per training institute, and so on. So we will never have perfection. I strongly personally believe it is the enemy of the good. So what we have is what we have. And by applying the lens of legitimacy, applying the lens of fairness, and questioning the sources. For example, just last point, Professor Karnam's point on the kind of violence and torture that happens in prisons or in police custody. We cannot use it. We don't use this data, right? But, and Christoph is, or others, techies in the room, can we enumerate those cases by applying a code and picking up that sort of information from the media universe through, and then corroborate it, test it, verify it? But it is something that we should head into and not simply get stuck into the supply side, but also remain very alive to the human side of the story. And while we compare it with Pratham and Asar, we are very aware that it is not exactly that simple. Where you put an Anganwadi center, you give a weighing machine, you supply the portion kit, and you can change the weight, and you can cure SAM and MM, all of that. You can't do that in the sphere of justice. It will always leave somebody unhappy, somebody wanting for more, and so on. But on the supply side, last point. There are 33 crore gods for the majority community in this country. You put every single volunteer and salaried person, contractual person of the justice system together, it will not be a fraction of that. So my appeal from the audience is, and Anand said, what is the way forward? What is the consensus that we can build? I don't think we can in this meeting. But can we agree that 20,000 serving judges may not be something that we need to quibble about, whether judge to population ratio leads to fewer arrears or pendency? We can maybe agree on that. Thank you.
Thank you. So we'll have to just leave it at that. I know some questions are answered, and hopefully we can respond to that in person. We passed one.
Can I get half a minute?
Okay.
Yeah, this may be a little unpopular thing to say in a colloquium on data for justice, but I've been thinking since last 2 days that this data is for what? We are all people, we are all working for and with people. So data is not for data's sake. We need the data to do something. And I see two kinds of people who look for data, not in this room, but outside this room maybe. There are people who are looking for data just to scrape that data and use it for something else. And there are people like us who want to use the data for a particular purpose, which is like working with the people with whom we work. And for those who want data for data's sake, they want more and more data to come out from the government without themselves doing the hard work. My whole point is, don't push the system to a point where they will forget what is their actual work and end up just producing more and more data for some other purpose. We should, that's why I'm saying that I may be saying something which is a little unpopular, but I just want to say, this is not for this people in this room. What?
NIC is missing from this room.
Okay.
NIC is missing from this room.
I really feel that we need to be a little cautious. What kind of data is required for all of us to work, and what kind of data is required for some algorithms to be made, for some other commercial purpose, is something that we need to be careful about. For those kind of data, do your own research. But the problem is, the system doesn't give permission. If I as a researcher want to go inside the prison, I am not trusted. I'm seen as an outsider. So we should trust each other. There should be some level of vetting, credibility, and allow us into the system, allow us to do research. We are not against you. We will come out with some unhappy facts. We can work with that. But, and this RTI thing is happening because the system is not allowing you inside. And then you're coming up with all kinds of fudged data. Then you know that you cannot use that RTI data beyond a point and things like that. Sorry. That was a rant.
Thank you. On that, no, sorry. I'm so sorry, right? We'll come back in the last session. Again, there's, thank you, Valay, Pooja, and Vijay for those thoughts and reflections, and all of you for coming in. And I was telling Valay that this would be a session where people have lots of things to say, and we're going to be short on time, even if we had 2.5 hours. The next session is the concluding session, sort of a double agenda there on what is the role for big data in the future of the criminal justice system, and also what is the role for data in future reform strategies. So on that, we have Apar Gupta talking on the role for big data, surveillance, and all the sort of slightly worrying future trajectories of use of big data in criminal justice. We have Professor Aparna Chandra and Rukmini and Professor Mohan Gopal in that session to talk about how do we imagine the role for data in future reform strategies, if at all. So we'll have lunch and come back at 2:30. It's 1:40 right now, and we'll have the concluding session at 2:30. Yeah, I'll see you all back here. Thank you.